members of the audience. So the object of my presentation really is to compare and contrast the two different remedies which are available to plaintiffs in a design case, which is design's infringement and passing off, and sort of delve into the overlapping protection between designs and trademarks. And I would, in the latter part of my presentation, try and deal with some of the troubling questions which, according to me at least, they are troubling, and which the judges or the courts in India have not really conclusively answered. So this is, I've just reproduced section 2D of our Designs Act, which defines a design. As you can see, it includes features of shape, configuration, pattern, ornament, etc. However, there is a statutory prohibition against a registration of design which is otherwise eligible to be protected as a trademark under the Trademarks Act. Now, if we move on to the definition of a trademark under the Trademarks Act, and if you contrast these two definitions, you will see that there is no corresponding prohibition under the Trademarks Act against protection of a trademark which is otherwise qualified as a subject matter of a design. And obviously, shape of goods is a subject matter of design protection as well as subject matter of a trademark protection. So this is the concept of overlapping of rights between the design statute in India and the trademarks, although there is an express prohibition under the design statute against protection of shapes which are otherwise qualified under the trademark statute. There is no corresponding provision under the Trademarks Act. And as we move further in my presentation, we would see that more often than not, and definitely in the last decade or so, through several judgments of the Bombay High Court and Delhi High Court, passing off as a remedy, where basically the plaintiff is trying to say that the shape or the particular design features, even after the expiry of a design, has somehow transformed, transcended or morphed into more of a source origin, and therefore has become a indicator of source, an indicator of origin, and therefore achieved the status of a trademark, and therefore it should be independently protectable. So design infringement is broadly covered under section 22 of the Designs Act. The test really, we are pretty much familiar with it, which talks about something which is a fraudulent or obvious imitation. And obviously, several activities are prohibited, which is sale or import or publishing or exposing for sale of any article which is otherwise an infringing article. Now, one thing to bear in mind is that a registration of a design, you get a registration of a design for a particular goods in a particular class, and therefore the scope of the protection of that registration is only limited to that particular class. The last bullet point which I have covered here really is whether a senior registered proprietor of a design can sue a junior registered proprietor of a design for design infringement, and this issue was troubling for several years, and it was first answered in Dabur, if I'm not wrong, and recently in 2013 in the Microlube case, which is the full bench of Delhi High Court, they have again confirmed that suits can lie against registered proprietor of a design also. These are some of the tests to determine design infringement. Again, I don't want to delve too much into it because I want to focus more on the contrasting of these two remedies, design infringement versus design passing off. But I think one key aspect which I would like to cover here is that the similarity or difference in two rival articles has to be judged solely through the eye. And therefore, I think this is the test which has been adopted by various courts in India as to whether there is a design infringement or not. These are some of the defenses available to defendants in a design infringement case. Prior publication, previous registration in India, lacking originality, lacking novelty, etc. But I'm going to delve more into the functionality as a defense, because there has been quite a lot of confusion and in the past in India, and several courts in India, both in the Bombay High Court and Delhi High Court, have kind of given contradictory decisions. So although the term functionality is not really used in the design statute, And the design statute really doesn't say that if a design is functional, it should not or it ought not to be registered, or it does not deserve protection under the Designs Act. But there are various other terminologies used which seem to indicate that if a shape of an article or if an ornamentation or anything else is basically solely dictated by functionality and otherwise there is no visual appeal, then it does not merit design protection. Now, earlier there have been judgments where if the defendants have proved that the design is functional, the design has been struck off, or the defenses had been admitted. But I think in the last 5 years or so, there have been several judgments which seem to indicate that just because a design or a shape is functional in nature does not mean that it cannot be protected, so long as there are certain other attributes to that design which are visually appealing. Or in the words of Justice Chandrachud in the Bombay High Court judgment of Whirlpool, design elements which are capricious. I think the two landmark judgments really are the Whirlpool case and the Gorbachev case, the Gorbachev vodka case, where the design of a vodka bottle was in the shape of the onion-shaped dome of the Russian Orthodox Church, and therefore the design of the shape of the vodka bottle had nothing to do with the functionality of that, and therefore it was entirely capricious. There are judgments in India which clearly seem to indicate that so long as there are certain capricious elements to the design, even if the design is partly functional, it still merits design protection. Passing off, now there have been again, I think one of the earliest cases is the Tobu case, which I'm going to deal in the next slide, the Tobu case in 1983, which basically held that design passing off as a remedy is not maintainable because the design statute in India does not expressly talk about design passing off as a remedy, unlike the trademark statute in India, which expressly mentions passing off. However, I think since 1985 or so, and more recently in the Michael Yu case in Delhi High Court, I think now more or less it is a confirmed view that design passing off and design infringement, both these remedies do coexist, and just because design is a subject matter of a statute and the statute does not mention about passing off doesn't mean that the plaintiff cannot avail of the remedy of passing off. I'm going to deal with the justification really or the rationale really for design passing off as a remedy. It has been held in several cases, which we have indicated in the slides here, that the passing off really is a tortious action and therefore is a common law action, and therefore it does not need any backing under a statute. Now this is a view which is taken quite contrary to the earlier jurisprudence which was prevailing in India, because for example under patents law we don't see any common law action of passing off, because Patents Act is specific as to what technology deserves patent protection, and if it doesn't deserve patent protection, then unless it is a trade secret, it goes into the public domain. So there is no action of passing off when it comes to patents. But under the designs law, certainly the courts have held that passing off as a remedy is available. Especially the Michael Yu case, the reasoning which was upheld in the Michael Yu case of the SmithKline case and other cases, where the court observed that purpose of both these legislations are different and hence protection provided is different, and therefore a composite suit for both causes of action is not maintainable. The court is basically trying to contrast the design which is subject matter of a design statute, the purpose of such a design, and when the design transcends into an origin of source and a trademark, and how it should be protected in the common law. This is where I dealt with the rationale for passing off, and one of the rationale which is given by several courts really is what is protected by trademark is slightly different from what is protected under the design statute, and passing off being a common law remedy, there should be no statutory prohibition over a plaintiff claiming design passing off as a remedy. And therefore clearly, whether the design is currently valid and is currently continuing in the term, or it has expired. If one can prove that there is reputation over the design, and that reputation is such that there is the consumers exclusively associate that design with the plaintiff, then certainly a design passing of remedy is available to the plaintiff even beyond the statutory term of the design. And this is something which has been also held by certain other UK high courts and UK courts. These are some of the UK judgments which really talk about why reputation in a product or reputation in a design in a product should not be protected beyond the statutory term of the designs. Some of my final thoughts really are that if the plaintiff has the choice of design infringement and design passing off as a remedy, then what should be the threshold or the standard of proof when it comes to granting of injunctions or finally ultimately at the trial in the passing of cases? Because in my view, various high courts have not really delved, including the Microlube full bench court judgment of the Delhi High Court, they have not really delved into the issue of what should be the threshold of inquiry or the threshold of proof or the burden of proof before granting an injunction in a design passing off case. Is merely reputation good enough? What sort of sales, what sort of volume of turnover is good enough? Or do you really have to prove something as we call as secondary meaning? So do you have to really prove that this particular shape or this particular design ornamentation is so distinctive, and because of continuous use over the years, it has achieved some kind of a exclusive association with the consumers in the given jurisdiction, so as to transform into merely a design and then go into the realm of source, origin and trademark law. And therefore, if that is the case, then common sense would suggest that there should be a higher threshold of proof before injunctions are granted in passing off cases. Because I think we desperately need some kind of a clarity, and no better than the Supreme Court of India to do that, in terms of what is the threshold of proof and standard of proof when it comes to granting passing off claims in the design context. Thank you.